we're litigious, right? Like we want to argue about things and we use evidence from the past to make claims. That's how humans are, and it is a way that the law works, but the law should be subject to infinitely more discipline than the specious, slightly fraudulent claims that kids are going to make in an argument with their parents over who failed to do something that needed to be done. And I think sometimes the law looks that way to historians rather than, well, I guess I hope that historians we hold ourselves to really high standards of evidence.
Jill Lepore, welcome back to the show. Great to have you.
Yeah, thanks for having me.
It's been a while. Not much has happened.
It's a good thing not much has happened, yeah.
Not much has happened. So I wanted to talk about one thing first that I noticed that has changed in your biography since we last spoke. You have for a long time been a professor of history. Great, very important. You are now on the faculty of a different kind of school that I'm familiar with, the law school. Am I correct?
Yeah, though I'm still a professor of history.
No, sure. You just you don't subtract, you only add, I know. What possessed you to become a member of the faculty at the Harvard Law School?
Oh, I've been teaching at the law school for a long time. We have a pretty close relationship. There are a number of JD, PhD students who also study history for their PhD. There are a number of us who've been affiliated faculty from the history department and vice versa. A lot of courtesy appointments of legal historians at the law school who are members of the history department. So a few years ago, I just said I wanted to formalize that and have a properly split appointment. And colleagues at the law school were gracious enough to allow that. So
do you think legal history should be mandatory at law schools?
Geez. I don't have a JD. So I find legal education somewhat baffling. I've sat in over the years, like way back to when I was working at Harvard as a secretary before I went to graduate school. I've sat in on a lot of law school classes. But I would say most of my sense of legal education really just comes from Paper Chase and Legally Blonde and the same set of kind of mid films that inform most people's sense of legal education.
Well,
I can give you a serious answer to that question.
Let me add a layer to it. I mean, in some ways, the study of law and the practice of law is all about history, right? We have a thing called precedent, which we have as lay people can talk about it in any discipline, whether it's history or economics or international relations, and you have these things called precedent, which are, less formal. One would argue that maybe with the Supreme Court, they are less formal as precedents in the law as well. But you are required as a lawyer, if you're going to argue any point in a court of law, in your brief or oral argument, to understand what came before on that particular point of law, and to understand why the thing that came before is either exactly the same, totally different, or somewhere in between. And so in some ways, as I think about it, and this is what I want to sort of get your sense of as a longtime historian, is the actual practice of law is an exercise in understanding history and convincing other people that your reckoning of history is correct. Is that fair?
I think that is fair, but in some ways, calling reliance on precedent a historical method is a bit of a misnomer. I'm not sure that history as a single term is capacious enough to contain the forms of reasoning that lawyers exercise in a courtroom or that judges exercise in writing opinions. And also history as a social science, that's kind of an empirical form of research, a history as a humanistic form of inquiry that is a branch of literature. History is asked to bear many burdens. People also use history to describe what I would just call folklore and myth. So yes, I agree in principle that the study of law contains within it an attempt to understand the relationship between the past and the present. But the foundations of that method in law school are really deeply different because they're based on instrumentality and advocacy, which are conditions and modes that are considered anathema in humanistic inquiry, right? I mean, there are plenty of historians that say, I am an advocate, my work is political, but the way I was trained as a historian, right, your work is never instrumental, and it is never meant to be a form of advocacy. And ideally, it really doesn't have anything to do with the present. So all the things that animate legal education and how lawyers talk about the past really violate the rules of the guild of history as an academic discipline. And I don't mean in a bad way. I just mean like they're different. And I've always found that really fascinating.
Well, there might be a bad way. On this program and on the Insider podcast that I also do every week, we have talked about the Supreme Court justice's interest in history and selective examination of history to justify various things, including the right to choose and all manner of other things. Do you, either in your teaching at law school or otherwise, have you formed a view about the quality of history scholarship on the part of our Supreme Court justices or others to defend their legal points of view?
I have many views about
right.
that.
Well,
and I've certainly written about it.
You can talk about originalism. You can talk about, this is an open field question.
Yeah.
You are the qualified historian. Judge the others.
No, I've certainly written about it a lot. I don't think it enters in much into my teaching. I think that's largely a question students have kind of to settle on their own, which is, what is the place of historical argument in justice and rendering justice. I would say that, like most academic historians, I find most briefs and opinions written by lawyers and judges that make historical arguments in the current moment, in the mode of originalism or the history and tradition, to be bafflingly obtuse.
That's you being kind.
That's me being kind. They're sort of like... I'm
going to write that down. Bafflingly obtuse.
They're willfully partial. And I don't mean partial in the sense of non-objective. They're willfully partial in the sense that the historian's obligation is, as best as possible, is to look at the entirety of the historical record and put it in a proper proportion that would make it recognizable. This is a little bit the way journalists sort of talk about the kind of no surprises rule. That would make your account of the past recognizable to people who lived in it. That is, I don't think, anything like the case with originalist opinions, which are recognizable only to us really as political machinations, not as faithful accounts of how people lived and died. And I don't really, I have this thing on my website because people often ask me how to write history. So I put up a handout that I used to give out in my American Revolution class, I think now 20 years ago. It's called How to Write a Paper for This Class. And it's sort of my rules for writing history. And it kind of begins with it's probably bad enough being dead without some asshole just basically using your life and times to make a political argument. And I really believe that. But that's probably a fair description of what a lot of historical argument in the law does, right? No, I don't know. I mean, I'm not sure that that's all bad, right? Let's say, in your family, let's say you have a house and you have 5 kids and everyone has a different account of who forgot to bring the dog in and the dog got frostbite overnight. Well, there's a kind of whole history to how that argument would play out in your family, right? There's the one kid who is never does what he's told, and there's the other kid who we know that she said she came in at 10, but she didn't come in till midnight, and so she had forgotten. We walk through life with we carry around. Since we have precedents, right? When you get in an argument with someone in your family, you're going to point out the last time someone forgot to bring the dog in, it was you, and I know it was you, Preet, because I remember that time. We're litigious, right? We want to argue about things, and we use evidence from the past to make claims. That's how humans are, and it is a way that the law works, but the law should be subject to infinitely more discipline than the specious, slightly fraudulent claims that kids are going to make in an argument with their parents over who failed to do something that needed to be done. And I think sometimes the law looks that way to historians rather than Well, I guess I hope that historians hold ourselves to really high standards of evidence and to rules of evidence. That in fact, genealogically, our standards of evidence and rules of evidence come from the law, right? Like just historically, that's where they come from.
Yeah.
But they look different in academic scholarship.
If I can draw a distinction between practitioners and judges, both of whom are supposed to be beholden to the law, and you could, I think, reasonably suggest should be held to these high standards of evidence and argument and historical fact, et cetera, et cetera. But, lawyers as advocates, I sort of feel, can be more easily forgiven for trying to sculpt an argument a little bit selectively out of history to be zealous advocates for their client.
Yeah.
What is less excusable and more, looking at my notes, what is more bafflingly obtuse is why the courts, and indeed the highest court, engages in that kind of thing, unless it's the case that a lot of people think already that justices and judges are advocates too. And they're not calling balls and strikes, to pick a different metaphor used by Justice Roberts famously. Is that your sense, that the judges and justices are just advocates too?
Yeah, I don't want to think that.
You don't want to think that.
I take your distinction seriously, but I am also inclined, just dispositionally, to grant the benefit of the doubt to these people that they believe themselves to be acting in accordance to principles, that they believe that originalism is an intellectually consistent mode of constitutional interpretation, even indeed that they swallow some of the craziest things that people say about originalism, that somehow it's democratic, or somehow it is original, or somehow that is true to history. I guess I tend to believe that justices on the Supreme Court who are originalists are true believers. True
believers in what?
True believers that in originalism, that theirs is the one and only true way.
Right.
I mean, it has always had a kind of evangelical vibe, and
isn't it a little peculiar? Originalism is a doctrine or a mode of interpretation that originated, to use a term, when?
So it certainly is not original.
Right.
It's not possible that it could have been original. First of all, there's so many times when the framers say, God help us if people actually wonder why we did what we did, because that should not determine anything, or why we wrote what we wrote, or who knows if this will last. Like the sense of contingency and accident, there's a lot of puffery. Like you read the Federalist Papers, it's like reading Mark Andreessen's techno-optimist manifesto. It's like, it's a new era for humanity and all will be great. But
that
they're selling
comparison I have not yet heard. Mark Andreessen is very flattered.
They're selling it. No, he shouldn't be flattered. I intend to no flattery, Mr. Andreessen. They're selling it, and they are excited about it, but they're very clear. Don't worry, we put Article 5 in there because we know we effed up all over the place. From the very beginning, first of all, a lot of these guys won't sign it. Then Franklin makes this great speech where he's like, I'm only signing it because I know we effed up and it's fine, because that's what we always do. We're fallible and it'll be fine because future generations can fix it. But also, one of the principal claims of originalists is that there's this finite number of historical documents that determine the meaning of the Constitution, and we're meant to. And these and no other documents are available to us to understand the original intent, meaning of the Constitution. And most of those documents were not available to judges before the 1980s.
Yeah.
It just the notes of the state ratifying conventions, some of them weren't printed until the late 19th century. Even the Federalist Papers were a little bit hard to get a copy of. Madison's notes weren't available until the 1840s. There's just not that stuff. It's not original. It's just on the ground. That's not true. So that is for sure a problem with originalism as you can't really be defended on the grounds that is original. When did it emerge? Well, you see, deference to the original intent of the framers all the time. I mean, I would say, most notably, and of course, most infamously in Dred Scott, right? Dred Scott is an originalist opinion. It's not a label they would have used then, but, his premise from the start is, no Black people in the United States can ever be citizens because we must defer to the original intent of the framers. And as I read these documents, they could not have foreseen this moment. So, but I would say the modern era of, so you see these, this reference to original intent now and again, but you also see many other modes of interpreting the Constitution. It's like one among many. It doesn't become something that presents itself as the exclusive and only legitimate means of constitutional interpretation really until the 1980s. You see how strongly, a lot of this book that I published this fall, We the People, that's a history of the Constitution, most of it's really not about the Supreme Court, because my whole argument is the history of the Constitution is not the history of Supreme Court decisions. It's the history of a lot of other things. But, there's this really important moment in 1954 when Earl Warren, having asked the two sides in Brown v. Board to submit historical evidence answering a series of, I think it's 6 questions about the 14th Amendment, he just says in his opinion, the historical evidence is inconclusive. And if we were to defer to the history and tradition of segregation in this country, we would never end it. So therefore, it's over. like he just abjures.
That's not bad. That's not bad.
He just abjures the whole notion of that as a mode of constitutional interpretation. And yeah, sure. There's the impeach Warren movement. There's a huge backlash against it. But one form that the backlash takes is the early roots of originalism in its modern form.
So state the last point, maybe more starkly, if I took your meaning. If originalism had been the prevailing doctrine of interpretation or mode of interpretation in 1954, and 6 of 9 justices on the Supreme Court subscribed to that method of interpretation, what would have been the result in Brown v. Board?
Well, if Fred Vinson hadn't died of a heart attack, we probably would have had a different result. We didn't have to be that counterfactual to get to your interesting formulation. Yeah, I don't know. You can't I'm not a very good cast backer and timer, but yeah, it took.
Would have been different.
It would have been different, right? And that was the whole argument of the NAACP, right? But in a way, it's Warren who goes further. But that's where the NAACP's move of we're going to bring in social science evidence, because actually there's plenty of other evidence than turning to the 14th Amendment. There's plenty of other evidence than turning to the Constitution of 1787. There's all the evidence about how we live now. And this should obtain, that work that began with Brandeis in whatever is Muller v. Oregon or whatever, presenting reams and reams of statistics and quantitative evidence and social science evidence to break free of the stranglehold of the dead hand of the past, right? That's what that move was about. That's what the progressive movement was, right? Wow, we're really stuck. We have this Constitution. Great, great, great. It's great. It's lasted so long. We love it. But we need, what about maximum? What about maximum hour and minimum wage laws? What about ending child labor? What about having a federal income tax? How are we going to end indirect election of the Senate? I guess we can amend the Constitution. Okay, great. But then the child labor amendment fails. And I guess we got to just find a way to convince the court. We got to really shake up the court. And it's, and we enter a different era, but we enter the era of the Warren Court.
In the real world, outside of legal opinion and outside of lawyers arguing one side or the other, whether they employ historical analysis or not, whether they employ it correctly or not, it seems to me that American society sort of moves on from a controversy and decides in its collective wisdom or lack of wisdom that a certain thing was good or not, or right or not, right? Most people are not sitting around and necessarily parsing the rationale for the unanimous decision in Brown v. Board. But I think most people in the political, not just the center, but the wide swath of Americans have accepted and agreed that that was a good decision, and that separate but equal is inherently unequal, not based on the mode of interpretation that was used, but based on some generalized, you'll have better words than I will, but some generalized overlapping consensus of where we are as a country. The same may be said of generally speaking, minimum wage rules, child labor laws. We kind of fought those fights, however those battles were done, by whatever mode of interpretation, persuasion, et cetera, in the court. And that's part of like the infrastructure and governing law of the country. That's an inartful way of trying to make a sort of an establishing point. Is that all fair?
Yeah.
Okay. If that is so, in recent times, I had Erwin Chemerinsky, the dean of UC Berkeley, on the other podcast on this morning. We talked about the phenomenal rate of undoing of things. Does society need that kind of repose, say on minimum wage laws, child labor, things like that? And what does history have to say about what does and does not work in a country when there can be reliance on something like reproductive rights for 50 years and that can be undone? That's not an artful question, but could you talk a little bit about how American democracy functions insofar as it's good not to have to relitigate basic fundamental things every few decades? Or should we?
I was at an event at the Kennedy School here at Harvard, maybe 2 or 3 years ago, when a colleague at the Kennedy School did a little exercise with the audience, a few hundred people, mostly probably undergraduates. And it was like, bring up your phone and scan the VR code and answer this survey. And the survey was, on which of these, in the matter of any of these questions, do you feel that your view on what is right lies beyond the realm of debate? Mm-hmm. And so it was like a lot of like guns, abortion, birthright, citizenship, immigration stuff, just different claims. And of course, like, it wasn't clear what the audience believed on any of these issues, but it was just an alarmingly high number of people. Well, maybe not alarming to you, I don't know. Maybe not alarming to anyone. To me, kind of surprising.
Bafflingly huge.
I'm a frequently baffled person. Let's say it's 50%. I do not remember. 50% of people were like, at least one of these, like, or maybe many of these issues were just completely beyond the realm of reasonable debate. And so his point was, these are things that we call fundamental law. Like if you don't think that then they're, most of them involve constitutional rights. You'll have discerned, right? And you'd think that constitutional rights ought to be stable, or if anything, they could be subject only to an additive process. We could add rights, but taking rights away seems counterindicated by the very notion of a constitution or a Declaration of Rights, or a Bill of Rights. So, but people were so mad at this exercise because he was sort of making the claim that the fact that so many of these things feel emotionally to Americans like constitutional rights is what's freezing up is one of the many factors that's freezing up our democracy, because people are unwilling to debate them. So it's an interesting exercise, but I think that what it also misses is, do you know that book by Jamal Green, How Rights Went Wrong?
I have not read it, but yes, I'm familiar with it.
Okay, so it's great. I highly recommend it to your listeners. Really brilliant book in which Green is sort of arguing that all this stuff in our law goes in this bucket of constitutional rights in a way that's always winner take all. My right to not being discriminated against for having a same-sex relationship that's leading to a marriage, and your religious freedom right to not have to bake a cake for me intersect, kind of come into conflict with one another. And only one of us gets our rights out of that. And that's just a volatile system. And that's the way that our rights revolution, that's the form of our rights revolution or rights creep or whatever you want to call it, that it has led to these insoluble conflicts over winner take all rights disputes.
But
that's a different vantage than Erwin Chemerinsky. So I guess I was just kind of emphasizing that.
But I have sort of a bigger question that has been bothering me. in the same vein of what is in fact settled and what percentage of the population has to believe in something for it to be settled. And the particular place that gives me great pause, more than baffles me, is something that a guest once said, and I always forget who it was, but someone very smart, that, even in Western liberal, long-standing democracies like the United States of America, there is a not insubstantial percentage of people who, if the autocrat was on their side substantively in terms of outcomes, they would support authoritarianism to get the things that they want. And I asked this person, what was the latent percentage of people in a population like America who might think that? And she said it was like 20, 25%. That's pretty fundamental. And then you get to more specific things that are also very big and important, not as fundamental as constitutional republic, but the First Amendment, free speech, and whether or not certain kinds of speech should be restricted, hate speech or otherwise. And a lot of people come at those views in bad faith, but a lot of them come at those views in good faith. And they look at other functioning constitutional democracies that do not have written into their charter the kind of First Amendment that we have. I guess the question is, how much is really settled? What are the things you can name that are fully settled by and among 85 or 90% of the American public?
I'm not a political commentator in this sense.
I know.
It's not a historical question. I think history would tell you that nothing is settled, right? Like why and how
that's
could it be?
Scary to me. I've only recently thought, why am I so late in understanding that? Don't you have to answer that question about my obtuseness?
Look, the introduction to this book is called The Philosophy of Amendment, and I argue that our written constitutional system is based on the philosophy of amendment. It's based on the idea that things can always change. It may sometimes be necessary, might even be urgent, might be a little change, might be a big change, might be an improvement, might be a correction, might be a repair, might be making moral amends.
Right, but it's not suicide. It's not, as someone famously said, the Constitution is not a suicide pact. It's not the doing away with constitutionalism. On that, we should be. You would want a constitutional democracy to have, 98% buy-in for the basic premise, or let's say even a subset. Separation of powers. I don't know. There's some people who are pushing the line about co-equal branches of government, one more co-equal than the others. I don't have a question. I don't have a question there. It's just sort of a general lament, and I wonder if
but just to push back on that, I mean, and on the Chemerinsky point as well, is it things you like are being undone, or things are being undone that concerns you? Because those are different claims.
Yeah, no, but among the things I like are these very, very, very fundamental things like separation of powers and feeling antithetical towards autocracy, believing in due process, believing in process over outcome. Those things, I think, I do. I like them. I would like to hope that everyone likes them. I'm not talking about things like abortion or gun rights, or even some things that are not even creatures of the Constitution, but creatures of statute. I practice criminal law. I practice it now. I practice it on the other side for a long time. Those laws change and have to evolve all the time. My own thinking about incarceration and about imprisonment and about punishment have changed, fairly dramatically in the last number of years. That's all good, but are there things about which there should be, as John Rawls used to talk about when he invoked Lincoln, an overlapping consensus to sustain, this experiment going forward?
Yes, I don't mean to waffle on that point.
Yeah, okay.
Absolutely, that's absolutely the case.
Okay, so what do we call the 250th? It's a very hard word.
It's a semiquincentennial.
Oh, that's very difficult. Can you come up with a better word than that?
No. The bicentennial was so.
I was 8 years old.
Bicentennial. What'd you do for the bicentennial?
So the bicentennial was 1976. I was 8 or 7 or 8, and I was in second grade. And I just remember the whole year was just full of stuff. And we had the quarters, And there was a train.
Were you in New York?
I was in New Jersey.
Okay, yeah.
And I feel like my immigrant family. I was not born in the United States, naturalized citizen. Wasn't even naturalized at that point. And I remember going to see a train.
The Freedom Train.
The Freedom, was it the Freedom Train that purported to have the Constitution on board? Can that be right?
Yeah. Did you also see Wilt Chamberlain's sneakers though? Because that was a little bit to me at 10.
That's
we went
a
to
founding
the Freedom
document.
Train too, and I was like,
that's a founding document.
Yeah, I don't care these documents, whatever. They're like old, but the sneakers. I remember the sneakers.
But it was a big deal, and I feel like there was a lot of civic education around it. I don't think I was brainwashed too terribly in any particular direction. I don't remember anything. I was 7, but it was great and it was cool. And I think we went to Disney World that year, and for the Bicentennial, maybe they still do this now. So maybe it wasn't special. I think they had like a 4th of July parade every day.
Every day, yeah.
For 365 days.
Yeah.
It was wonderful. Is this one going to be wonderful, Jill?
I've been spending a lot of time thinking about that, reading about the Bicentennial. Everybody I meet, I ask them what they remember from the Bicentennial. It's fun.
Are there memories similar to mine? Do I?
It really matters whether you grew up or not in what one historian I met calls the OG 13.
So if you're in Oregon, it's different?
It's just different. Oregon, they were like, "Wah." And also, like, a lot of the stuff didn't go there, like the tall ships and the Freedom Train. Didn't make it all the way. Yeah. So, but if you talk to people who grew up, especially on the Eastern Seaboard, but broadly in the OG 13, people have, very detailed memories of it, and not often deeply cynical ones. But maybe it's just by definition, they're going to be older people who look back with a certain nostalgia at that era. I mean, I remember I was talking to a neighbor when we were out for a hike, and she said her little sister was really into it, but she was a teenager, and it was like, oh God, like I can imagine the teenager ennui, and
teenage ennui. That phrase has not been used on this podcast before.
The teenagers really hated it. But actually, I will say there's quite fascinating work on how many civic institutions were founded or received sustaining funding during the Bicentennial from the federal government. These are state, municipal, local, like little from your neighborhood history museum or house tour place to, a kindergarten curriculum about the town's history, or a city neighborhood's series of public artworks. Like, just the amount of money that was pumped out, really mostly via the NEH, right, which no longer is doing that. They're doing something very different and in a much smaller way. And the federal government is certainly not pumping out money to the states and to towns and cities right now. So it is a very different moment, but I think the comparison is a really useful one. I guess I just want to flag that the bummer of the Semiquincentennial name is you can't, for instance, have Bicentennial. Do you remember the Bicentennial? Like 100-mile bike race or something. Like all these like fun.
Nice puns. I think we're just going to call it the 250th.
Yeah, which I don't know. It just seems old.
I'm not even aware of what celebrations are underfoot. Are we going to drop bombs? Is there going to be a lot of military action? What does our commander-in-chief have in mind? I don't even know.
The Arc de Trump? You haven't heard about the Arc de Trump? There's a replica of the Arc de Triomphe being built in D.C. or planned for being built in D.C. I think he maybe has been distracted by the ballroom, so maybe the Arc de Triomphe is not going to happen. But there were such magical things. I wrote a piece for the New Yorker this fall about when Trump was making all these declarations like, I'm going to get you, Smithsonian. Watch out. I'm coming for you. Bam, bam, bam. Left, right. Look. Like this nonsense. And I went back to try to figure out what Trump was doing at the Bicentennial. And it's hugely embarrassing. Like, it seems like he just carries around.
Atlantic City? Atlantic City?
Among the many. No. So I think his father had just been imprisoned. His father was very briefly imprisoned. I don't say this without fact checking it against my magazine piece. I don't want to say something untrue. But there'd been all the scandal about the Trump company's fair housing violations. But Trump that year, in that spring, was pitching a big convention center at the site of what became the Javits Convention Center in New York. There was going to be like all the things, the dictator-style gold chandeliers and the ballrooms and the casinos. And it was going to be, he called it the Miracle at 34th Street. And he gave this big presentation as a photo of him appeared in the paper with his, 1970s tie and looking like a beardless Don Jr. And he was kind of laughed out of Manhattan. People were like, what are you talking about? We're not doing this. And then he went, really, I think like maybe July 1st of 76 to DC and pitched a very similar convention center to DC. And both of these were billed as bicentennial infrastructure projects that would revitalize these failing cities. And in DC, he was really blocked by, basically was going to demolish, again, I could be misremembering certain details, but demolish some DC neighborhood that was like majority Black, and a big neighborhood organization had a big presence at the meeting, and they really laughed at him. Like the newspaper reporters are like, they laughed this guy, this wiseacre Trump from New York out of town. And I just sort of picture him walking out of that meeting in DC in July 2nd or 1st of 1976. The city is flooded with tourists. There's going to be just the biggest fireworks ever. The whole National Mall is a display of American folk life. Like there have been the Smithsonian folk life programs have brought in people, banjo players and dancers and fly fishermen and shrimp catchers, just people with all kinds of skills, and, dancers, singers, musicians, artisans, just this huge celebration of American pluralism and creativity. And you picture this young Trump like stomping away from a meeting, storming away in a fury at this. Yeah. He's going to show this town. That's how I feel about the arc to Trump. I think he's finally getting what he wanted in 1976.
Look, arguably on another occasion when he was mocked and made fun of and humiliated at the White House Correspondents' Dinner in 2011, a lot of people think that's the origin story of a successful run for president. Not once, but twice. So people humiliate Trump at their peril.
Yeah, no, I know. That's why it seems like a not unreasonable explanation for his particular vision for America at 250.
Can we go back to something that we were talking about and back to your book from a couple of months ago about amendment? So on this point of which things are settled and maybe nothing is settled ultimately, because I guess we could have a constitutional convention and we could put it all on the table. That's difficult to do. And you argue, I think, very cogently about the need for there to be amendment, and for lots of reasons, including log jams in the House and the Senate and the difficult ratios you have to meet. Amendment has become a dwindling form of advancement, progress, or at least just generic change in the Constitution. I'm not sure what kind of answer I'm looking for, but for the good of democracy, how difficult should it be to amend the Constitution?
I think it's worth emphasizing that the formula that is in Article 5 was crafted before there were political parties in the United States, and at a time when they could not have been anticipated, because the framers understood parties to be inimical to republicanism. Like a republic couldn't have parties or it wouldn't survive. So they weren't accounting for that. So the fact that it's hard to the point of being impossible right now is not because it was meant to be impossible, if that's what we cared about most. It's an accident of history. So there have been many attempts to fix that, because that's, was the case, within a matter of decades, that it was too hard. And it hasn't been possible to fix it. So I'm not sure that there lies a lot of likelihood of it being fixed. My point in the book is that its difficulty introduces a deformity into our system of separation of powers, which you so cherish so rightly. Because if the only way to change really the main way to change the Constitution is going to the court. It just puts way more power into the hands of the court and more power into the hands of presidents, of the executive in making those appointments. But then those appointments themselves also become far more consequential. And then in our lifetimes, of course, subject to incredibly intimate public scrutiny, which are really surprising, right? Like that's not what, like we shouldn't really know the names of the wives and husbands of people on the court. Like it's weird. But so that I guess my point is more like that's a deformity. And I think it also, you have to kind of become willing to tolerate that deformity before you get to the current deformity, which is the one in which the president decides what the Constitution means. Like that's not part of our system, but you have to have become so comfortable ceding the power of the people to interpret or to amend the Constitution for a long time before you get to the point where people are like, it's okay. I mean, he can, if he says there's no birthright citizenship, okay. And if he put the people on the court who are going to say that there's no birthright citizenship, maybe, I mean, okay. Like most Americans believe in birthright citizenship. Like,
yeah,
that's just like one of the bigger swindles of all time, right? It's in the Constitution because it was put in the Constitution by the people, and Trump gets to take it out. Like this. So this wasn't an answer to your question. I'm sorry, but I don't really have an answer to your question about how easy or how difficult it should be.
But it should be easier than it is, you think?
Yeah, I think it should probably be easier than it is, and I think the fact that I think we should be less fearful of it, honestly. I think a lot of people, like historically, there's tremendous evidence of people on the left being fearful to seek constitutional amendment because of the possibility of losing. Yeah. And, that's also kind of how democracy works. So
yeah, you look in a microcosm, a few years, I guess every certain number of years, I guess various states, this must be true in various states, but certainly true in New York State where I live, you can open up the Constitution of the state to a convention, and every time this comes up, there are people lobbying back and forth. And it's a pretty liberal constitution. And it seems to me, if I remember correctly, a few years ago, I was asked to get involved. I didn't. I had other things to deal with. But the progressives are afraid of losing ground. And I wonder if that's always the case. I mean, on a national level, if you have the executive branch, if you at least at the moment have the legislative branch, and you have for a long time to come the judicial branch in the form of the Supreme Court, you don't kind of need to open up the Constitution, right? You got your folks amending it sort of ad hoc along the way, right?
Those Supreme Court decisions that amount to a de facto amendment can be overturned by that same court once the ball's going the other direction down the court, right? So even if you think about, you think about, say, the NAACP in 64 and 65, after the Civil Rights Act and the Voting Rights Act, you can go back into their papers and there's some discussion of like, okay, great. So now, should we try to constitutionalize these by way of an amendment? And there's not really much internal discussion because people are like, we won. Why do we want to risk losing? Like we just finally fucking won. Like, shut up. Like, no. That's a kind of response after Roe v. Wade as well. Like, okay, you get this.
Why didn't we pass a law?
Same thing with same-sex marriage in Obergefell in 2015. Like, okay, we won. Why would we take the risk of, well, there is an answer to the why, right? Which is because these things can all be overturned. Although, fair to say, like the 14th Amendment was basically ignored for 50 years, so it's not clear that an amendment is all that.
Do you have any amendments, Professor Lepore, that you would like to see considered and adopted?
Part of this book came out of a project that I've done for the last 4 years. I mean, it's over now, called the Amendments Project. It's a free online searchable database of every meaningful attempt to amend the U.S. Constitution. So it's thousands and thousands of proposals. You could search them by year, by date, by topic, by state, by party. I spent a lot of time with my research team of Cracker Jack undergraduates compiling that. And we used to do Amendment of the Week. Yeah, I would give away prizes for whoever had found the most fun amendment.
What was the prize?
Oh, the prize was usually like a Frederick Douglass kitchen magnet, or one of those cheesy.
Exactly what I would have guessed.
Yeah, one of those cheesy national parks, historic museums, shops, parchment declarations of independence. So yeah, they weren't like hot items.
It wasn't like crypto.
Oh, yeah, I thought I'd give out crypto.
You were not giving out Dogecoin to anybody. Okay.
No.
So wait, so what were among the popular amendments?
It's more that people would bring in just the wackiest. It is so long ago, I don't even remember any of them. They're just this framed, the language of them. So a lot of the amendments that are introduced on the floor of Congress, of which there have been 12,000, they're just kite flying, right? So people, they know they're not going to get anywhere. I mean, before there was the C-SPAN clip that you might use in your reelection campaign, there was, the newsletter, or, you could tell constituents, I introduced 4 constitutional amendments. Yeah, and so a lot of them were just like constituent surfing. And so they were funny. They were like hyper local and weird and statutory and like just not anything.
If I were to go look at that scholarship and I mean to, what I find the most interesting amendment and then undoing of an amendment in history, I think, no booze, booze.
Yeah.
If you could give a very short history lesson, given your expertise on amendments and history, the hell was going on in America that caused that?
Yeah, the best thing is Lisa McGurr, my amazing colleague Lisa McGurr, has a fantastic book on the war on alcohol. That's the rise and fall of Prohibition. I guess here's the thing. Here's the thing that I often forget when I think, what were they thinking? Temperance was a women's rights movement from the start, and it was. Before women had the right to vote, it began before women had the right to own property, right? Before the Married Women's Property Act. And one way, in all of the women's rights campaigns were moral crusades. And one thing that women very strategically thought is, okay, we're completely at the vulnerability of a husband who might become a tyrant, who can take all of our money, hide his wages, drink all the wages, beat me up to death, rape me with no legal consequence, all but murder the children in a drunken rage. And so, their thinking was, hey, one way to protect our rights to live and have a family and protect our children from violence would be to outlaw alcohol. It's not a crazy idea, given there's nothing else they can do. They can't vote. They can't charge their husbands with crimes. They can't, there's no child welfare agencies, right? It's before the children's rights movement or even child welfare or the anti-cruelty to children's movement. So I think it looks just like such a kind of crazy, like, who are these harridans? No, they were women's rights activists who wanted a lot of things. They want all kind of rights, but they weren't going to get those. So they want some protections. And a big avenue for that was temperance, which then becomes, the temperance movement becomes the home protection party, right? Like it's all about protecting the home. So I think it's charitable to remember that context. There's also that kind of marries a huge anti-German sentiment, right? The German beer halls are a huge distribution network for beer and the drinking of beer. And, before and during the First World War, the anti-German sentiment is huge. So you can see how those things could sort of explosively combine. Then there's the military preparedness before the First World War. Like, we need the troops to not be drunk too. We need to actually clean up the country in this drinking way. And the amount of drinking people did was of a scale that we could probably really not anticipate. It's sort of more like the way we might think of the opioid epidemic today.
What we see in Russia or the Soviet
So that's where I think you get prohibition. How you get repeal
the
is...
oops. How did the oops happen?
Yeah. Also, the other thing that people forget about prohibition is the main way the federal government was funded was by taxes on alcohol. So once the 16th Amendment is ratified in 1913, granting Congress the power to tax incomes, that makes possible taxing incomes enough to enter the war in Europe without alcohol money. How you get the repeal is it doesn't work at all. People are incredibly miserable, and
crime.
It's really there's the sort of criminal underground, and it's a little bit that attached to opposition to federal power and the New Deal.
Yeah, look, it could have been more crazy, right? could have had a system in which public education was funded by tax on alcohol, right? I don't know why that's any more weird than on property. Can I ask you about one more amendment? So Franklin Roosevelt, if I remember correctly, was a very popular president. And he did a lot of things. And the New Deal was still is not settled, but he was credited with a lot of good stuff. So popular that he crushed the opposition 4 times. And not long after that, we amended the Constitution to limit terms to the George Washington preference of 2 terms. Is that unusual? Is there anything, what lesson is there to take from that? And the reason I mention it is, in these conversations that I would have with people at think tanks and elsewhere about Trump's first term, and certainly in the second term, there was a lot of discussion about the kinds of things on a bipartisan basis we might do to codify norms. It was a norm that a president would only serve 2 terms. It was not in the Constitution or in the law. And on a bipartisan basis, we did some of that. We didn't really do any of that after Trump won. Pick any aspect of that to comment on.
Well, this isn't commenting on that, but I do spend a lot of time in the book talking about why FDR pursued amending the Constitution by way of the court instead of constitutionalizing the New Deal by Article 5.
Yeah,
that's a big piece of the story, the history of amendment. I think the presidential term stuff, actually one of the evergreens, it's constantly introduced. I think even in 1787, 1788 was introduced as a proposed amendment, is a single non-renewable 6-year presidential term, which is an idea that I really, really like. It's been dormant for a long time. It's not infrequently reintroduced. But by constitutional design, it's something that actually, to me, makes a lot of sense. But we're not in a position right now as a country by way of this process to codify norms, right?
Yeah.
We have to find other mechanisms for codifying norms. And the methods that are on the table seem pretty weak, right? Like that's the source of your anxiety about nothing being settled.
Last words before we let you go back to your other business of the day. Say something hopeful, Professor, for the country.
Hope is cheap.
That was not it. We're going to have to cut that out of the program. It's the end of the year. People are both happy and in the doldrums. Look, a year has gone by, and when a month had gone, so I'll say something, it's not hopeful, but it's about how I've experienced time. When a month went by, it felt like years of the Trump 2 administration. And now it's been almost a year, and it doesn't feel like 10 years to me. It feels like, we got 3/4 of the way to go. It's not much of an optimistic note. But how have you experienced the passage of time?
I have experienced
one day at a time. You're going to say,
yeah. No, I think it's actually interesting as a historian noticing that people really perceive of themselves as actors in a historical moment, and I think that's actually useful because it gives us a vantage on which way to steer the ship.
Jill Lepore, the book "We the People: A History of the U.S. Constitution." We'll talk about amendments some more when we get a chance. Thanks so much. Take care.
Thanks a lot.
Hey, folks, never miss an episode of Stay Tuned. Hit the subscribe button now.